And we begin on the eve of the 4th of July, during a time in America when a lot of people are seeing their freedoms being taken away. And that is in large part due to the Supreme Court of the United States. Mainly, the court's 6 conservative judges, whose decisions last week, peeling back some rights and protections Americans have enjoyed for decades, were tainted by corruption. And no, I'm not just talking about Clarence Thomas and Samuel Alito's fancy billionaire-funded vacations. I'm talking about their total disregard for the idea of standing, the legal concept that lawsuits in any court can't just be brought on the grounds that an individual or group is unhappy with whatever the law is. That is not how it works. The plaintiff has to actually suffer some kind of injury. It's pretty basic stuff. But apparently 6 of the justices on the highest court in our country must have all missed that day in law school, as they've demonstrated in some of their latest rulings. 303 Creative versus Elenis, for example, the case that basically gave businesses across the country a green light to deny services to customers if they are LGBTQ. That was all based on a completely made-up scenario. Plaintiff Lori Smith, backed by the far-right Christian group Alliance Defending Freedom, sued the state of Colorado because she wanted to make wedding websites someday, but didn't want to make them for gay couples because it goes against her religion. But here's the catch. No gay couple ever asked her to make a website for them. According to court filings from the plaintiff, a man named Stewart contacted Smith in September 2016 about his wedding to Mike. He wrote that they would love some design work done for our invites, place names, maybe even a website. Well, the New Republic reached out to this Stewart to learn that not only did he never once ask Smith for any of this, he's not even gay. He's been married to a woman for 15 years. And that call with the New Republic was the first time he had even heard about the case. Meaning, what is now the law of the land was all completely based on a hypothetical. Whether or not they had standing was completely irrelevant, however. And this is a pattern. The case ending affirmative action, for example, was brought by another far-right group, led by conservative activist Ed Blum, who is white. That group argued that Harvard's and the University of North Carolina's policies discriminated against Asian Americans. But here's the weird thing. No Asian American students came forward to testify to having experienced said discrimination. In fact, the only students, Asian American or otherwise, who testified were in favor of race-conscious admissions. And with the student loan forgiveness decision, the court ruled in favor of 6 red states who were challenging President Biden's executive order. Not actual students who had loans or debt. But the Supreme Court doesn't care who the plaintiff might be, if they have any involvement with the case, or if they even exist. If the plaintiffs don't have standing, the 6 conservative justices will just make it up. Whatever it takes to keep handing down these draconian decisions that align with their political ideology and right-wing religious views, and that keep the right-wing billionaires who take care of them happy and fueling up those private jets. Joining me now is Melissa Gira Grant, staff writer for The New Republic, Dean Obeidallah, MSNBC columnist and host of The Dean Obeidallah Show on SiriusXM, and Maya Wiley, president of the Leadership Conference on Civil and Human Rights. Melissa, welcome to the show. I do want to start with you. Let's talk about this 303 case, because it seems to me that it is a case based on a completely made-up thing and a man who didn't know he had any involvement with it. And I think you've done some reporting on it.
Yeah, I started the reporting on it. This case is based on something even more made up than this individual inquiry for a wedding website. So the main claim that Alliance Defending Freedom was bringing in this case was that their client was not allowed to even advertise her business making wedding websites, which did not exist. So there's a business that didn't exist. She's not allowed to advertise through that business, they said, allegedly because of an anti-discrimination law, which is the law they have now eroded. And then in the midst of that, they bring this inquiry from an alleged same-sex couple. ADF is spinning right now. They're trying to say, oh, this doesn't matter. We brought this on much bigger grounds. But like 2 things to know about that. The much bigger grounds are actually even more imaginary than this inquiry, if that's possible. You know, she has yet to advertise for this service. And they're saying it's a pre-enforcement challenge. And yes, those exist. And ADF often loses them, actually, when they're on the other side. So this is something that was meant to affirm the religious rights of this woman, Lori Smith, and people like her at the expense of queer and trans people. ADF can spin it however they want right now, but the reality is this person whose name is on the inquiry, Stewart, he didn't make it. There is no genuine same-sex wedding inquiry behind this. And ADF attested in court that there was.
And just to be clear, Melissa, did you talk to Stewart?
Yes. I found Stewart's contact information in the course of going through court filings. And when I spoke with him, I expected him to say, oh God, I've heard from a million reporters, like here's another one. But he hadn't. No one had called him before. He had no knowledge that his name appeared in this court filing. He had actually heard of the case because by the time I called him, like last Tuesday, the case had been argued at the Supreme Court and it was in the news a little bit at the end of last year. So he actually knew about it in the context of his work as a designer. Like, that's the other kind of ridiculous thing here, right? Like, he's a designer. Why would he be trying to hire another designer to make this non-existent wedding website? So he's somebody who supports LGBTQ rights. He supports abortion rights. Everything that ADF is for, everything that this case is about, he stands against that. And it's just a very disorienting experience for somebody who's truly just a private person who, for reasons that are still unclear, his information now has become part of this case as if he is a real half of a same-sex couple.
And just to be clear again, he's not part of a same-sex couple because he himself is not gay.
Correct. Yes. Stewart is married to a woman. Stewart has been married to a woman for more than a decade. I'm just like a little anxious to get into the particulars of who he is because he is truly a private person and lots of people have been calling him. Also, given the reality of this case and who ADF is allied with, I think his concerns for harassment and backlash are pretty significant. And I think that I've spent a lot of time texting with him, talking with him, and my sense of him is that there's just no reason on earth that he would have placed this inquiry. And also, to be very, very clear, I don't know for sure. I don't live inside Stewart's computer. It may come out that he did. Even if that is the case, what ADF is claiming, that this is a genuine inquiry, that's still false.
Okay, so I wanted to establish all of that, Maya, before I come to you to ask how this is not illegal, deeply unethical. We're going to come back to ADF in a moment. But this sounds like a completely specious case. How could it have possibly come before the Supreme Court? And how could they go through oral arguments and go through this entire case and that never come up?
Let me just say, Joy, first of all, Melissa, thank you for that reporting because, when you bring a case, you're supposed to have what's called a case or controversy. That means something has to actually have happened to you. It's part of what we think about the courts. You have to have something called standing, which is that you are supposed to say that you have had some form of palpable injury. And I think what Melissa has walked us through is exactly the point of there was no case, there was no controversy, there was not even any stated injury because she didn't have a business. And this did come up in lower courts. And ADF kept changing its filings to try to assert that it had something there, including months after it filed its original complaint, kind of updating it to show this alleged request that appears to be false. So I think at the end of the day, you said it right, Joy, when you said this isn't supposed to happen. You aren't supposed to be able to get all the way up to the Supreme Court without any factual case that demonstrates that you should be able to be in court in the first place. And on one level, if in fact this was fabricated, it would be a felony because you have to affirm under oath. That would make it perjury if it's untrue. But I think at the end of the day, it goes back to your other point, is the Supreme Court wanted to take this case, even though it flew in the face of decades of Supreme Court precedent that said, you know what? You don't have to open a business. If you are religious and have strong views, you are allowed to have those views, but that doesn't mean you're allowed to deny anyone else service if you open a service business. And what it did is say, we don't care.
Well, I mean, we know that they're trying to enact their religious and political views. I think that's very clear. But the one more specific question before I bring Dean in for you, Maya. Should there be and can there be sanctions against the attorneys? I mean, can they keep their bar licenses after making up a fake case and arguing it? And can there be sanctions against the members of the Supreme Court who knowingly affirmed a case with attestations that were lies?
Well, first, someone can always ask for a disciplinary proceeding against the attorneys. Of course, like all things, there has to be evidence that they, in fact, knew that there were attestations that were not fact-based. So like all things, we want to see due process, but absolutely on sanctions. There's something called Rule 11 in the federal courts where you can be sanctioned and actually fined money for not paying attention to the rules of the court. In terms of the Supreme Court, you know, as we know, we need ethics reform. As we know, the only way to really go after any Supreme Court justices for wrongdoing is impeachment. And we are pushing very hard for ethics reform as a civil rights community, as the Leadership Conference on Civil and Human Rights, because we simply can't have a Supreme Court and law of the land that the people can't trust.
Well, you can get 67 members of the United States Senate. Think about your voting when you vote for the Senate, because if you got 67 Democrats in there who are willing to impeach one or more of them, they could win an impeachment. That is the way it works, just like with the president.